Chuwen Dai, hi. You're an associate at the International Arbitration Group of White & Case in Paris. You're focused on international commercial and investment arbitration as well as public international law. Prior to joining White & Case, you've gained experience at the Office of Legal Affairs of the United Nations in New York and the UNCITRAL Secretariat in Vienna, and a number of international law firms in China and in France. You graduated not from Berkeley, but from Harvard. That's okay. Today you'll talk about conducting virtual arbitration hearings, which is quite interesting at the moment, I guess, for all of us. And I'll hand it over to you, and thanks for being with us.
Thank you, Christoph. Although I did not graduate from Berkeley, but I have to say that I'm affiliated to Berkeley because my husband went to Berkeley last year. He graduated from Berkeley Law last year, so I'm very happy about it. So let me just set up the slide. And so I would like to thank the Berkeley Global Society and Osborne Clarke for hosting this wonderful event and giving me this opportunity to share this topic, trends in international arbitration, with other excellent panelists. And let's jump right into the topic. So the topic I would like to discuss today continues the discussion of the previous two panel speakers, is the attractive features of international arbitration, which relates to its procedural flexibility and more frequent use of modern technology during the proceedings. I think arbitration may be more ready to embrace changes, such as the use of virtual hearing in the current COVID-19 world. The pandemic is doubtlessly a disaster for our global community, but it also has an unexpected effect of accelerating digitalization and adaptation to modern technology in a wide range of industries. For arbitration, this may be the last puzzle to make the entire proceeding virtual, because as we have all experienced, we are already doing a lot of our work virtually, including communicating with our clients and exchanging documents, and also filing submissions, even for interviewing with the witnesses and experts. And although I agree that conducting in-person meetings and discussions is certainly more engaging and effective, but we now frequently just hold such meetings through video conferencing because it's more efficient and cost effective. And the only occasion requiring the physical presence of all parties involved at one place is the hearing. However, as affected by the pandemic, our ability to travel has been significantly reduced, and full in-person hearings have become almost impossible in the past few months since the lockdown and closing of borders in different regions. So some member of my team have already conducted fully remote hearings in the past few months, and I am scheduled to have one in the coming few weeks. So I think it will be timely to discuss some salient features relating to virtual hearings. First, so I will cover 4 points. First, what are virtual hearings and the relevant regulatory framework in international arbitration? And second, what are the considerations for a tribunal to hold a virtual hearing? And third, how to ensure due process in virtual hearing. And finally, what are the practical considerations for conducting a successful virtual hearing? First, let's look at the definition of virtual hearings and the relevant regulatory frameworks in international arbitration that provide the legal basis for conducting virtual hearings. A virtual hearing, as you can see here, of course, we know what it is. And it's a hearing where two or more locations interact simultaneously by audio or video transmission. Of course, usually through video. And there are two ways for semi-remote hearings. There is usually one main hearing location and one or more remote locations. For example, we can examine a witness or an expert remotely because they cannot physically travel to the hearing venue due to certain restrictions. So this is actually relatively common, and we have done so in many hearings already. And as Professor Maxi Schreier recently wrote, remote hearings are nothing new, but the COVID-19 crisis has forced international arbitration out of its comfort zone. So the second type of virtual hearing is the fully remote hearings, and all participants are at different locations. And my discussion today mainly focuses on the fully remote hearings. So currently, due to COVID-19 pandemic, even the council teams may not be able to gather physically together at one place. And so what is the basis for holding a virtual hearing? As we know, all arbitration rules provide that parties have the right to oral hearings. For example, Article 25.2 of the ICC rules provides that the arbitral tribunal shall hear the parties together in person if any of them so request, or following such a request, it may, of its own motion, decide to hear them. So here I underlined the use of the words together and in person. So some have argued on this basis that virtual hearing is therefore not possible because it requires the parties to attend their hearing together in person. But this is, in the view of many, not the correct reading of the ICC rules. If you look at other linguistic version of the ICC rules, they do not necessarily contain the wording in person. And also the ICC has clarified that virtual hearings are possible under its rules. In its recent guidance, the ICC notes that Article 25 does not require in-person hearings. And this article is intended to provide opportunity for live adversarial exchange, and a hearing can be conducted in person by virtual means. None of the other articles in the ICC rules can be read to require in-person hearings, although tribunals in a particular dispute may decide that an in-person hearing is necessary. So I refer again to Professor Maxi Schreier. As far as she's aware, there is no arbitration rules or national statutory rules that mandate or prohibit virtual hearing. But it is indeed recognized that most of the national statutory rules do not address the issue of virtual hearing. And some parties may insist on physical in-person hearing in order to delay the arbitration proceedings. This is presumably raised more often by the respondent in a case. In this circumstance, parties may have to make submissions to the tribunal to request or reject or object to a virtual hearing. So this leads to my second point. So what are the considerations for a tribunal to order a virtual hearing in the event that the parties cannot reach an agreement? So in the case of objecting to virtual hearings, various submissions have been made. For example, a party may argue that seeing the witness in a serious case is vital, and the importance of live interaction between counsel and the tribunal and between tribunal members themselves cannot be overstated. So under all the main arbitral institutional rules and national statutory rules, tribunals have the discretion to make the hearing happen, and counsel and parties are expected to cooperate. So in consideration whether to hold a virtual hearing or not, a tribunal has to balance two conflicting factors. On the one hand, there is a duty to conduct the arbitration as expeditiously and efficiently as possible. So for example, if the postponement of the hearing has the potential of introducing harm to one party, this may tip the balance towards a virtual hearing. And on the other hand, the parties have the right to equal treatment and the right to be heard. So here, the UK and Singaporean courts have held that virtual hearings do not in themselves deprive the parties' rights to equal treatment. It is indeed a case-by-case analysis. For example, when the parties do not have the same access to technologies and one party cannot effectively participate, this may affect one party's right to equal treatment and to be heard. And some institutions have already set out the considerations for tribunal in determining whether to proceed with a virtual hearing or not. For example, the ICC refers to factors such as the nature and length of the hearing and the complexity of the case and the number of participants, and whether there are particular reasons to proceed without delay, and whether rescheduling the hearing would entail unwarranted or excessive delay, and the need for the parties to properly prepare for the hearing, and whether the awards will be enforceable. So this leads to the next point of my discussion. How do we ensure due process in a virtual hearing? So the first common issue that many are concerned about relates to witness examination in a virtual hearing. So there is a real risk of witness coaching when it comes to virtual hearing or remote examination of the witness. So for example, there is an anecdotal story that a colleague shared with me that many years ago, he conducted cross-examination of a witness through video. So before he started, he asked the witness to turn the camera around and show him the surrounding. So my colleagues suddenly heard noises of footsteps and door slamming in the room before the witness turning the camera around. So we do recognize that witness coaching is a well-founded concern. However, it is also agreed that this concern may be slightly exaggerated, and because our modern technology indeed allowed us to examine the surrounding and have a closer and clearer view of the witness. So this makes it easier to spot any interference with the witness testimony, and whether the witness is cheating. If there is a real and serious concern of witness coaching, there will be mitigating methods, of course. So another important issue is the validity and enforceability of an arbitral award when the hearing is held remotely. It has now been widely agreed that as long as there were no demonstrable due process concerns, no national courts would set aside an award solely on the ground that the underlying hearing was held virtually. And in a recent webinar held by the SEC, it is noted that according to an investigative study, there is no one single publicly known court decision where an award has been set aside on the basis that all or part of a hearing was held virtually. So in order to ensure due process of the hearing, it is also critical to make sure that the virtual hearing runs smoothly so that the parties have an equal opportunity to make their case in front of the tribunal and are not disadvantaged by how the hearing is conducted. So lastly, I would like to briefly address some practical considerations for conducting a successful virtual hearing. We have to admit that virtual hearing is still new to us, and when we are not familiar with the relevant logistics, it is certainly more complicated for planning. But I believe that it is just a matter of habits and adapting to the relevant technologies. So first, it may be desirable to agree on a protocol with the tribunal and opposing counsel in advance of the hearing, regarding the use of audio and video feeds, raising objections and the manner and methods of interrupting anyone who is speaking, and also make sure that you have the backup plan when the technology fails, so that we know how the parties will communicate with the tribunal. This is also to prevent ex parte communication with the tribunal in order to ensure due process. And second, it is strongly recommended by many colleagues to run multiple rehearsals before the hearing. So we need to make sure that all the equipment for each participant has been tested well in advance. If possible, organize a couple of short trial runs with all participants. This will ensure that all of them have had an opportunity to familiarize themselves with the technology. And another related tip is to adjust hearing timetable accordingly. Because we need to build in a time for dealing with technology failure and to accommodate participants in different time zones and to have more hearing breaks, because people's attention span actually seems to be shorter in a virtual setting. And to conclude, I would like to share with you a recent report from my colleague who just concluded a virtual hearing. I quote, "We had our virtual closing hearings Tuesday and yesterday, 1 day and a half of counsel submissions, and a half day of experts conferencing with participants sitting in Sao Paulo, New York, Atlanta, Birmingham, DC, Santiago, Germany, Italy, and Paris, of course. It was held in WebEx, via WebEx, organized by White & Case, and everything went very well. It took multiple rehearsals over 2 weeks and an IT vendor coming in to make sure that the WebEx worked well for everyone, but picture and sound were eventually perfect thanks to huge efforts put in by the team. Our IT colleague even had to get on the phone several times with 2 of the arbitrators to assist them with technical issues. And I learned that restarting the computer and internet box resolved 90% of all issues. I'm still of the view that nothing replaces an in-person interaction, but this was pretty close to the real thing." End of quote. So will there be a paradigm shift towards virtual hearing, or would fully remote hearings become the normal in the future? And I think the current crisis forces us to engage in this exercise. And I think both physical hearings and virtual hearings have their merits and deficiencies. So I leave it to all of you to consider and think about what your preferences would be. Thank you.
Thank you, Anna. That was really interesting and a topic that affects us all. Again, we'll allow questions after.